So now we turn to that question of how do you prove the case? How do you prove a case of religious discrimination? We talked a lot about this in terms of race and sex and national origin. How do you prove a case of religious discrimination? Well, proving the case is different because of the duty of an employer to accommodate religion. Now, the law provides two means of bringing a claim for religious discrimination. There's two theories that can be used to support a claim of religious discrimination. And the first is an employee can bring a claim that the employer treated him differently because of religion. This is classic disparate treatment. I was treated differently than someone else in a similar situation because of my religion. The second way to bring a claim is to bring a claim alleging that the employer failed to accommodate the employee's religion. And we'll talk about this accommodation process in a minute. But accommodation is going to be another way in which the prohibition on religious discrimination differs from the other types of prohibitions. So we start with disparate treatment analysis. Disparate treatment analysis, again, requires different treatment because of religion. And the prima facie case of disparate treatment based on religion is the same as for other Title VII classes. You must be a member of the protected class. You must have applied for and been qualified for the job. You must have been rejected from the position, and someone outside of your protected class was hired, or the employer kept looking. In this case, Wolf v. Voss Lighting is a case out of Tulsa, Oklahoma. And it involved a lighting company there, electrical company named Voss Lighting, which was a branch of a nationwide company. And they were looking for a manager in their accounts department. And they ran an ad in the supervisor's local church bulletin. Now, one of the members of the church saw the ad in the church bulletin, and although he was not interested in the job, he referred it to a friend of his, Mr. Wolf, who met all the qualifications for the job. And so Mr. Wolf arranged for an interview with Voss Lighting. Now, Voss Lighting had only advertised in the church bulletin, and so the supervisor, when Mr. Wolf arrives, is somewhat surprised that he's not a member of the church. And for the majority of the interview is not about his qualifications for the job. Instead, it's about Mr. Wolf's particular religious beliefs. What does he believe in? What does he not believe in? Does he go to church? What church does he go to? Does he go to Sunday school? Would he be willing to come to work and participate in a Christian reading group without being paid for it? So all of these religious questions, very few of the questions concerned his actual ability to do the job. Well, Mr. Wolf didn't get the job, and so of course he filed a lawsuit, and Voss found itself in the position of being unable to defend it because clearly they had treated Mr. Wolf differently only because of his religion. And that's classic disparate treatment analysis. Now, the employer defends by citing legitimate non-discriminatory reason or BFOQ, just as any other disparate treatment case. In this case, Sharon, Elderman, and Reyes versus St. Xavier University. It involved a woman who worked for a Catholic university, and she was a professor there, and she was what we call an assistant professor. And assistant professors are on the tenure track, and then at some point you make an application for tenure. Tenure is going to, with the decision to grant tenure, is going to be based on your teaching abilities, on your research skills, as well as your service to the university. And so she applies for tenure. She's been somewhat successful as a professor and applies for tenure and is denied tenure. Now, Miss Elderman Reyes believes that she was denied tenure because she's Jewish and she's working in a Catholic university. And she has some evidence of that in terms of comments that her department head had made regarding Jews and about Miss Reyes individually. Nevertheless, the university is able to establish that this decision had nothing to do with religion, and that in fact Miss Reyes was denied tenure in the same way that many other people are denied tenure, that if you don't meet the requirements, you don't get tenure. And if you don't get tenure, you actually have to leave the school. It's a up or out type situation. So this is an example, however, of were able to establish the legitimate non-discriminatory reason as a defense to this disparate treatment claim.